Welcome. On behalf of the Institute of Law and Economics, I would like to welcome you all to this year's Distinguished Jurist Lecture. I asked Michael Walker, as we're coming up here, why we decided to start at 4:45. It struck me as an odd time. And he said, in light of all the financial developments, we wanted to make sure that all the U.S. markets were closed so that everybody would be checking their BlackBerries before the lecture. So I would ask all of you to please turn off cell phones and BlackBerries. I assure you the markets are closed because we're just looking in the China or Japan. In any event, obviously, as we look out in the world, there are a series of financial crises that are occurring, and that the economics and finance are at the centerpiece of much thinking both in the United States and abroad, which is a short way of saying is there's never been a more important time to be thinking about issues of economics and especially law and economics. And in that regard, the Institute of Law and Economics here at Penn has really been in the forefront over the years in trying to integrate the fields of law, economics, and finance. It's a joint effort between the law school, the Department of Economics, and the Wharton School. It also brings together luminaries from the judiciary, from practice, and from Wall Street to really think through all of the complicated issues of how we regulate our environment. And the impresarios of that, Professors Michael Walker and Ed Rock, and now newly entered Geo Fish, have really been sort of at the forefront of this effort. The Distinguished Jurist Lecture, has allowed us to spotlight lawyers and especially members of the judiciary who have been in the forefront of this thinking. And that is especially important, I think, right now as we're thinking through questions of professional ethics, that this is a moment to have somebody who is at the center of thinking about law and the economic environment. And in light of that, it really is a delight to welcome a distinguished graduate of the University of Pennsylvania, somebody who has really thought through many of these issues over the years. The Honorable Randy Hollen has served with distinction on the Delaware Supreme Court. He was the youngest person ever to serve on that court when he was appointed in 1986. And as Justice Veazey said, as you're looking at Randy, he was appointed at age 5 or 6 at that point. He was unanimously appointed and unanimously reappointed in 1999 for another 12-year term. As we all know, the Delaware Supreme Court is if not the most respected state court in the United States. It's known for having created a fair and reasonable litigation environment, and it really has developed an international reputation as a source of corporate law jurisprudence. And Justice Holland has clearly been at the forefront of that effort in writing some of the most significant opinions in the area. Professor David Skeel interrupted us on our way up here to say that he had to teach a class and couldn't make it to the lecture, but he allowed that 45% of the opinions in the casebook he was teaching had been written by Justice Holland. He has written in a wide variety of areas, including poison pill provisions, and is known for the depth and business sophistication of his opinions. He's also well known for his reputation in the professional responsibility area, especially professional ethics. Here at Penn, we can claim some foresight in that regard. When he graduated in 1972 with honors for the law school, he won the award for legal ethics here at Penn. And later we were honored to really bestow upon him an Alumni Award of Merit. He's been widely honored in the profession for his contribution. He's received the Judicature Society's Herbert Harley Award, reserved for individuals whose outstanding efforts and contributions result in substantial long-term improvements to the justice system at the state level. He is also well known as being the past president of the American Inns of Court, which fosters excellence in professionalism and has an extremely active chapter not only here at Penn, but across the country. In that regard, he received the 2007 Sherman Christensen Award, which recognized distinguished, exceptional, significant leadership at that organization. Of that award, Justice Sandra Day O'Connor wrote, "I cannot imagine a better nomination." The organization also credited him in bestowing that award, saying he is largely responsible for the current health and structure of the American Inns of Court. He has raised the international stature of the Inns throughout his tireless efforts to build a lasting relationship with the English and Irish Inns of Court. In that regard, he is only the third American judge to be elected an honorary master of the bench by Lincoln's Inn in London. The other two are Justice Ruth Bader Ginsburg and Justice John Paul Stevens. He's also been involved in a number of other areas of professional responsibility in improving our profession. He was appointed by the American Bar Association president to the Presidential Commission on Fair and Impartial State Courts. He chaired the National Advisory Committee to the American Judicature Society's Center for Judicial Ethics, and he led the American Bar Association's National Joint Committee on Lawyer Regulation. Obviously, the list goes on and on. Even though a judge and obviously actively involved in presiding in court, he's written extensively on a wide variety of issues. You might say he's met the tenure requirements at major law schools as well. He recently co-authored Middle Temple Lawyers and the American Revolution, which illuminates the influence of lawyers who studied law at the Middle Temple Inn of Court in London. In the foreword to that, Chief Justice Roberts wrote, what an excellent book this was and how it offered a deeper understanding of the nation's leading colonial lawyers and the influence of the Middle Temple. Justice Holland has also written several books about Delaware's Constitution and is a great historian of the history of the Delaware Constitution. So as you can see, he's somebody of great reputation both in Delaware but across the nation. But just as importantly for our purposes, somebody has deep insights into corporate law as well as issues of professional responsibility. I can't think of a more distinguished jurist to be giving this year's lecture. Will you welcome Justice Randy Hollen?
Thank you, Dean Fitz. It's an honor for me to be here. It's always nice to come back to your alma mater, especially when you don't think there's going to be a test. I'm honored by all of your presence here today and by the invitation to be here. I'm particularly honored by the fact that almost all of the members of the Delaware Court of Chancery are here, and my colleagues from the Delaware Supreme Court, former Chief Justice Beasley. And it will be a little intimidating for me to discuss their cases, but I'm going to try to get over that as we go along. For the students, you might be interested in knowing that we're in the Paul Levy building. And Professor Franklin and I, we're both classmates of Paul Levy, who's been extremely generous to the law school, not only with this building, but with a scholarship program. And I can certainly relate to that since I was here on a scholarship. So one thing you can learn from this is that if you go into the private sector, you can give the building. And if you go into the public sector, you can give the lecture.
Now, the University of Pennsylvania has had an illustrious reputation ever since it was founded in 1740 by Benjamin Franklin. And as you all know, in 1850, the law school was started by Professor Shardswood. But when I was preparing for my lecture today, I was keenly aware that the first lectures in the law were given here in 1790 by James Wilson. James Wilson was a signer of the Declaration of Independence and one of the justices on the first United States Supreme Court. And his views on the law were presented in lectures to President Washington and to members of the cabinet. I think Penn's tradition of academic excellence certainly continues today, and the Institute for Law and Economics is a good example. For more than 25 years, it's demonstrated the benefits of a cross-disciplinary perspective. Dean Michael Fitz has written, "The Institute for Law and Economics combines Penn's greatest strengths in the law school, the Wharton School, the Department of Economics, and it focuses on complex questions that concern all of those fields. Two of the great strengths in the law school are the co-directors of the Institute, Professors Edward Rock and Michael Wachner. I congratulate them on the Institute's remarkable achievements, and I thank you for inviting me to speak today. Now, Professor Rock is well known to all of you, and he's one of the foremost corporate law professors in the United States. He also has a well-deserved international reputation. More than a decade ago, he wrote a brilliant law review article entitled Saints and Sinners: How Does Delaware Corporate Law Work? And he concluded that the Delaware fiduciary law is best understood as a set of parables or folk tales of good and bad managers and directors. According to Professor Rock, collectively, the tales that are told by the Delaware judicial opinions describe the role of directors. I must admit, when I first read the title, I thought that you would cast the Delaware judiciary in the role of saints. But the litigants would play the role of sinners. In the article, Professor Rock concludes that the Delaware judges on the Court of Chancery and the Supreme Court are good storytellers. And notwithstanding the rather fact-specific narrative quality of the opinions, over time, they yield reasonably determinative guidelines. In reaching that conclusion, Professor Rock successfully analyzed and answered several questions, including what he describes the mushiness of Delaware fiduciary law. Now, since I graduated from this law school, I immediately recognized mushiness as a sophisticated legal term of art. And as a result, just as I did when I was a law student writing an exam, I knew I couldn't leave my title with a mushy reference to fiduciary duty. So I amended it to have a focus on loyalty. And in my remarks this afternoon, I'm going to briefly describe why now loyalty is the central theme in the Delaware judiciary's stories or opinions about fiduciary duties. I'm sure that when most of you think about stories, the opinions of the Delaware Supreme Court and the Court of Chancery are not foremost in your mind. Instead, you might think of literature about the law, such as To Kill a Mockingbird, 12 Angry Men, The Caine Mutiny, novels by John Grisham. You also may think of movies such as Kramer versus Kramer, A Civil Action, or, given my remarks today, you might think of Wall Street with Michael Douglas playing Gordon Gekko. But you may also think of Shakespeare, because Shakespeare often referred to the law in his plays. And the pervasiveness of legal references by Shakespeare is understandable, since London is the home to the Four Inns of Court. They're the institutions that train trial lawyers, known in England as barristers. Many historians contend that Shakespeare had extensive contact with legal London. In fact, 7 of his plays were performed at the Inns of Court. The Merchant of Venice and Measure for Measure are his 2 primarily legal plays. From a legal perspective, there are parallel themes in both of those plays: the tension between justice and the letter of the law. In the end, both plays temper a strictly legalistic approach with equitable principles. We all remember that Shylock was entitled to his pound of flesh as long as he didn't spill any blood. The Merchant of Venice is often viewed as dramatizing the struggle of the Court of Chancery in England for the supremacy of its equitable jurisdiction. Interestingly, the Delaware Constitution of 1792 created a separate court of equity. That still exists today. And the equitable struggles described by Shakespeare are relevant today because the Delaware Court of Chancery has been vested with all of the historical equitable powers that were extant in England's Court of Chancery prior to the American Revolution. The Delaware Court of Chancery and the Delaware Supreme Court have repeatedly tempered a legalistic approach with equitable principles. As the Delaware Supreme Court stated in Shell versus Christcraft, inequitable action does not become permissible simply because it's legally possible. And one of the fundamental tenets of Delaware corporate law provides for a separation of ownership and control. And what's been called a cardinal precept of Delaware statutory law is a provision in 141A of the Code that says directors, rather than shareholders, manage the affairs of the corporation. For more than a century, the Delaware courts have tempered law with equity by recognizing that the directors' exercise of their statutory power to manage the corporation carries with it certain fundamental fiduciary obligations. An underlying premise, in fact, for the imposition of fiduciary duties is the separation of control from beneficial ownership. Delaware courts bring equitable principles to bear in those circumstances to protect the shareholder owners who may not be in a position to protect themselves by directly managing the company. It should come as no surprise that the Delaware fiduciary duties are an equitable response to the power conferred by statute. It should also come as no surprise that those equitable fiduciary duties date back to a decision of the Lord Chancellor of England in 1742. In Charitable Corp versus Sutton, the Lord Chancellor explained that corporate directors were agents and trustees required to act with fidelity and reasonable diligence. Ever since the Sutton decision, courts have consistently stated that directors of corporations are fiduciaries who must comply with the duties of care, described in Sutton as reasonable diligence, and the duty of loyalty, described in Sutton as fidelity. Now, corporate litigation usually involves a shareholder challenge to a board decision, generally a business decision, and shareholder lawsuits frequently seek monetary damages for financial harm. Shareholders can enforce their fiduciary duties in two ways: with a direct suit, if they can show personal damages, or through a derivative suits. The judges on the Delaware Court of Chancery and the Delaware Supreme Court are aware that shareholder investments are only going to be maximized if disinterested directors act in good faith to assess the relative risks and rewards of a business decision. The Delaware courts also recognize that directors would never pursue a rational but risky business decision if they were going to be personally liable. It's inevitable that some business decisions won't result in financial success, even if the directors properly discharge all of their fiduciary duties. And that brings me to the business judgment rule. The business judgment rule is an effort by the Delaware courts to temper a legalistic approach with equitable principles. The business judgment rule seeks to promote the full and free exercise of statutory managerial power granted to directors, while at the same time protecting the legitimate expectations of shareholder investors. The business judgment rule also traces its origins to 1742 and that decision by the Lord Chancellor in Sutton. In that decision, the Lord Chancellor expressed the court's reluctance to second-guess business decisions of corporate directors and articulated what's considered to be the first pronouncement of the business judgment rule. Now, Delaware amended its constitution in 1897, and it enacted a general corporate law statute in 1899. And ever since then, the Delaware Court of Chancery has been adjudicating disputes involving the internal affairs of corporations. Because those disputes are decided by individual judges on the Court of Chancery and not by juries, opinions are written, and they built up a body of Delaware corporate jurisprudence. The idea that directors owed fiduciary duties was probably first expressed in Delaware in the 1926 decision known as Bodell versus General Gas. In 1931, building on that, the Court of Chancery said that the requirements for invoking the business judgment rule are good faith and a bona fide purpose. In 1984, the Delaware Supreme Court refined the business judgment rule in what's now known as the seminal case of Aronson versus Lewis. In Aronson, the Delaware Supreme Court held that the business judgment rule is a presumption that in making a business decision, the directors of a corporation acted on an informed basis, in good faith, and in an honest belief that the action was taken in the best interest of the corporation. The director's fiduciary responsibilities to both the corporation and its shareholders have frequently been described as a triad: obligations to act with due care, loyalty, and good faith. To rebut the presumptive applicability of the business judgment rule, the shareholder has the burden of proving that the board failed to discharge one of those fiduciary duties in discharging its responsibilities to the corporation, either care, loyalty, or good faith. Now, to understand fiduciary duties of directors today, and in particular the focus on loyalty, we need to examine the evolution of Delaware's jurisprudence regarding those three responsibilities. And we'll do that by reviewing several well-known Delaware cases. The fiduciary duty of loyalty is a concept in the Delaware law that is traced back to Guth versus Loff, in which the Delaware Supreme Court held corporate officers and directors are not permitted to use their position of trust and confidence to further their private interest. The duty of loyalty is premised on the idea that directors are fiduciaries who have a quasi-trustee or agency relationship to the corporation. The importance of focusing on the duty of loyalty was made clear in Aronson, when the Delaware Supreme Court stated, "The protections of the business judgment rule can only be claimed by disinterested directors whose conduct otherwise meets the test of business judgment." From the standpoint of interest, Aronson held that means a director can neither appear on both sides of a transaction nor expect any personal financial benefit from it in the sense of self-dealing. In other words, you can't have a benefit as a director that isn't shared equally by all of the shareholders. Accordingly, Aronson held that if such director interest is present and the transaction isn't approved by a majority of disinterested directors, the business judgment rule has no application at all. Now, the pronouncements of Aronson in 1984 were completely consistent with what the Delaware Supreme Court had said the year before in 1983 in Weinberger. Weinberger is a decision about a corporation named Signal, which was the majority shareholder of a subsidiary known as UOP. Signal eliminated UOP's majority shareholders by a cash-out merger. Now, the antagonists in that story were directors named Arledge and Chidia, who sat on the boards of both Signal and UOP. And Chidia and Arledge did a valuation report for the benefit of the parent, Signal, that was never shared or disclosed to either the UOP directors or the minority shareholders prior to their approval at a lower price. In Weinberger, the Delaware Supreme Court began its analysis by going back to Guth versus Loft, and it stated there was no requirement for any embellishment. Quote, "The same rule that requires directors to have an undivided and unselfish loyalty to the corporation also demands there be no conflict between the fiduciary duty and self-interest." In Weinberger, the Delaware Supreme Court held there's no safe harbor for divided loyalties in Delaware. When a director is on both sides of a transaction, they're required to demonstrate their utmost good faith and scrupulous inherent fairness of the bargain. Consequently, in Delaware, individuals who act in a dual capacity as the directors of two corporations, especially when one's a parent and the other's a subsidiary, owe the same duty of good management to both. And in the absence of an independent negotiating structure or total abstention, the duty is to be exercised in light of what's best for both companies. Now, the Supreme Court's reference in Weinberger to an independent negotiating structure was highlighted in footnote 7. That footnote has now become very famous because the Delaware Supreme Court said the outcome could have been entirely different if UOP had appointed an independent negotiating committee to deal at arm's length. Now, for the last 25 years, the Delaware courts have emphasized the importance of independent directors in safeguarding the interest of shareholders by preserving the integrity of the corporate governance process. The era of the 1980s gave rise to a good example. In Unical versus Mesa Petroleum, the Delaware Supreme Court concluded that when a board addresses a takeover bid, it has an obligation to determine whether the offer is in the best interest of the company. And in that regard, its decision was no different than any other decision, and perhaps was entitled to the protection of the business judgment rule. But the Delaware Supreme Court in Unical continued its analysis with a caveat. It said, there are, however, certain concerns to a proper exercise of this function. Because of the omnipresent specter that the board may be acting primarily in its own interest rather than the interest of the corporation and its shareholders, there's an enhanced duty that calls for judicial examination at the threshold before the protections of the business judgment rule will attach. Accordingly, what we see in Unical is a procedural paradigm shift. The court held that before the business judgment rule applies to the adoption of a defensive mechanism, the initial burden is on the directors rather than the shareholders. The shareholders had to do two things. They had to show that they had a reasonable ground for believing there was a threat to corporate policy, and they had to show that their reaction was reasonable in relation to the threat. Importantly, for what we're discussing today, the Delaware Supreme Court said that proof is materially enhanced where a majority of the board favoring the proposal consisted of independent directors. Unical is significant for many reasons, but for purposes of loyalty, two come to mind. First, Unical caused the procedural paradigm shift and introduced the concept of enhanced judicial scrutiny before it applied the business judgment rule because of loyalty concerns. And most importantly, those concerns were not financial. They related to the personal self-interest of the directors who may wanted to stay in office. Second, Unical once again focused on independent directors as the guardians of the board's decision-making process. Since Unical, in other contexts, Delaware courts also give special significance to decisions made by directors who are found to be independent. Now, given the Delaware Supreme Court's emphasis on the importance of independent directors, it's interesting to note that the Delaware corporate statute never uses the term independent directors. Instead, the statute only talks about interested directors. Accordingly, in Delaware, we find that the characteristics of directorial independence are ascertained solely from judicial opinions. It's frequently been noted that although director interest and director independence are methods of challenging loyalty, the difference is significant. That was highlighted in an article by Chancellor Chandler, who's with us today, and Vice Chancellor Strine. A director is interested in a given transaction if she stands to gain monetarily from it. In contrast, independence, as developed by the Delaware courts, is broader than financial interest. It examines whether a director, although lacking in a financial interest, is somehow connected to an individual who is interested. If the director's decisions are not based on the corporate merits, but rather influenced by personal or extraneous considerations, the director's not independent. In determining independence, the Delaware judiciary goes beyond financial interests. Instead, it looks at a broader inquiry into subjective influences, sometimes called a sense of beholdenness. And we can see that illustrated in three cases: Martha Stewart, Oracle, and Biondi versus Scrushy. In the Martha Stewart derivative action, the Delaware Supreme Court held that independence is a fact-specific determination and that the Delaware courts must make a determination by answering two inquiries: independent from whom and independent for what purpose. That was the decision authored on behalf of the court by Chief Justice Veazey, who's also with us this afternoon. In order to show lack of independence, the complaint of a shareholder must raise a reasonable doubt about the director's independence. In other words, that they're beholden to the interested director. And in that particular case, the Delaware Supreme Court held that allegations that Martha Stewart and other directors moved in the same social circles, attended the same weddings, had some business relationships before joining the board, and referred to each other as friends were insufficient without more to raise a reasonable inference that they were not independent. Now we see a different outcome in Biondi and Scrushy and in Oracle. In Biondi and Scrushy, which was one of the first cases to come out of the scandals involving Health South Corporation, the company's special litigation committee filed a motion to dismiss. And the committee was made up of two directors who had close ties to Scrushy, who was the center of the investigation. And the ties were through charitable organizations. In Biondi, the alleged independence of the committee did not survive judicial scrutiny because the committee's relationships to the insiders demonstrated that they would have been beholden to them. A few months later, the Court of Chancery declined to accept the recommendation of a special litigation committee in Oracle. Now, I'm sure many of you noticed I'm wearing a University of Pennsylvania tie as a loyal alum. Well, in Oracle, they were talking about a different tie, not a necktie, and they were talking about a relationship to a different university. In Oracle, there was no question that the Special Litigation Committee conducted its investigation in good faith. Nevertheless, the Court of Chancery concluded that the committee failed to satisfy that it was independent because of the ties between the members of the committee and the people who were the subject of the investigation and Stanford University. So what we see in both Biondi and in Oracle is that the Court of Chancery has relied on non-pecuniary basis for finding a lack of independence and instead addressed the social and professional relationships that could have an effect on the decision-making process. Today, in the Delaware courts, when we're having questions raised about director loyalty, we see those type of relationships in the forefront of many of the allegations. Now I'm going to return to the duty of loyalty, but before I do, I wanted to briefly look at what's happened to the duty of care. To receive the benefit of the business judgment rule's presumptive protection, directors have to inform themselves of all material information. In Delaware, the applicable standard of care is gross negligence. And it's interesting to note that the gross negligence standard of care also traces its roots back to 1742 and the Sutton case. Now, the most significant case on the duty of care is the Delaware Supreme Court's 1985 decision in Smith versus Van Gorkum. In Van Gorkum, the Delaware Supreme Court held that the Board of Trustees of TransUnion breached the duty of care by approving a merger. In that case, TransUnion's chairman and CEO, Van Gorkum, brought about the sale with the help of another inside director, Bruce Chelberg. The remaining directors who voted on the merger were not informed until one day before the deadline required for the vote. And the Delaware Supreme Court concluded that the board was not entitled to the protection of the business judgment rule because of a failure to act on an informed basis. And in Van Gorkum, the Delaware Supreme Court took the unprecedented step of holding all of the directors personally liable for $23.5 million. Needless to say, the reaction to the Van Gorkum decision was concern. Some people have called it panic throughout the boardrooms of Delaware directors in the United States, because now the directors had to fear for their own personal liability. In 1986, in response to Van Gorkum and what was deemed to be a liability insurance crisis that the decision generated, the Delaware General Assembly passed a provision known as 102B7. And 102B7 permits shareholders of corporations to exculpate directors from paying monetary damages for gross negligence. So this is not something that the Delaware General Assembly made shareholders do. It was an opportunity for shareholders who said they couldn't get anyone to serve to entice them to serve on their board by saying, we trust you not to be grossly negligent, and if it turns out that you are, we're not going to require you to pay monetary damages. Now, what's important about 102B7 is you can't excuse directors, you can't exculpate them from not acting in good faith, from something they do intentionally, or from violating their duty of loyalty. Now, this came to the forefront in a case called Malpede, once again done for the Delaware Supreme Court by Chief Justice Veazey. And the question in Malpede was, if a corporation has a 102B7 provision and there's a motion to dismiss, can it be granted if the only allegations in the complaint are violations of care? And the Delaware Supreme Court said yes, which was unusual because in the past, if you showed that the board violated its duty of care, you would rebut the presumption of the business judgment rule, and the board would have to show entire fairness. What the Delaware Supreme Court said in Malpede is that we're not going to make people go through that exercise, because if we take all of the allegations in the complaint as true, and you've only alleged a violation of the duty of care, it would be a waste of time to have the board show entire fairness, because even if the transaction was not entirely fair, any violation attributable to gross negligence would be exculpated. Now, almost all corporations have adopted 102B7 provisions. And this has led most commentators, including professors here, to say that the duty of care is really not important in shareholder litigation. It's almost aspirational, and at the most it's used as an opportunity by the Delaware courts to shame directors who would not have to pay any money, and by shaming them inspire other directors not to engage in that type of conduct. Now, the effect of Malpede is that in all actions in Delaware courts against directors with 102B7 provisions, shareholders are focusing entirely on loyalty and good faith. So let us turn briefly to good faith. In several cases in the 1990s, the Delaware Supreme Court began referring to directors' fiduciary duties as a triad: care, loyalty, and good faith. Those cases suggested or implied that good faith was an independent fiduciary duty. Interestingly, shareholders seeking monetary damages alleged that directors did not act in good faith because, like a violation of the duty of loyalty, it couldn't be exculpated under 102B7, and it would be an opportunity to collect monetary damages. This brings us to the Walt Disney litigation. In the Walt Disney derivative litigation, presided over by Chancellor Chandler, the controversy was hiring and firing Michael Ovitz as Disney's president. In October of 1995, Michael Ovitz and Disney entered in an agreement which provided that Ovitz would serve for 5 years. In fact, he was terminated within a year. But under the terms of the agreement, he was entitled to a severance payout of $130 million. The Disney plaintiffs alleged that the compensation committee of the Disney board and the board itself had failed to consider the employment, the compensation, and the termination of Ovitz as president of Disney. According to the complaint, the board and the committee had only met briefly and had failed to act on his termination at all. In Disney, the lack of good faith was used to rebut not only the presumption of the business judgment rule, but the application of 102b(7). In denying the motion to dismiss, Chancellor Chandler held that sufficient facts had been raised to create a reasonable doubt that the board's actions were taken honestly and in good faith, as required by the business judgment rule, and if the allegations were true, the directors were not entitled to exculpation under 102b(7). Now, ultimately, at the end of the trial, Chancellor Chandler concluded that the board had discharged its responsibility and the decision was in favor of the board. Nevertheless, the Disney case, like Van Gorkum, raised considerable consternation in boardrooms because it permitted a claim of bad faith to survive a motion to dismiss and to go forward to a trial against the Disney directors. Now, in challenging the board's actions in Disney after Ovitz's brief but lucrative career, the plaintiffs contended that gross negligence was on a continuum, and at some point, gross negligence could morph into that a lack of care could morph into a violation of bad faith. Now, the Delaware Supreme Court, in a decision written by Justice Jacobs, who's with us, rejected that contention and held that a failure to act in good faith requires conduct that is qualitatively different and more culpable than a violation of the duty of care. In the Disney decision, the Delaware Supreme Court emphasized that from a legal point of view, the director's duty of care and good faith are distinct. Now, in the Disney decision, the Supreme Court gave some definitive guidance for directors in the future, and it gave examples of what would constitute not acting in good faith. First, where the fiduciary intentionally acts with a purpose other than that of advancing the best interest of the corporation. Second, where the fiduciary acts with the intent to violate the positive law. And third, where the fiduciary intentionally fails to act in face of a known duty to act and thereby demonstrates a conscious disregard for her duties. Now, this brings me back to Shakespeare. In Shakespeare's play, King Henry VI, the king asked, "Oh, where is faith? Oh, where is loyalty?" A few months after explaining the distinction between care and good faith in Disney, the Delaware Supreme Court addressed the relationship between loyalty and good faith and answered the king's question in the decision of Stone versus Ritter. The clarification between good faith and loyalty came in the context of deciding directors' oversight responsibilities. Stone was a derivative action, and in 2004, AmSouth and AmSouth Bank had paid $40 million in fines and $10 million in civil penalties to government agencies because employees of the bank had failed to file required suspicious activity reports. The complaint in Stone alleged that the directors breached their fiduciary duties by not properly discharging their oversight responsibilities. Now, the whole concept of oversight responsibilities had initially been addressed by the Court of Chancery in the Caremark decision about a decade earlier, but the Caremark decision had never been appealed to the Delaware Supreme Court, and consequently, it was addressed in Stone. And in Stone, consistent with its opinion in Disney, the Delaware Supreme Court held that Caremark articulated the two necessary conditions for assessing director oversight liability. One, the directors utterly failed to implement any reporting or information system or controls. Or two, having implemented such a system or controls, the directors consciously failed to monitor or oversee its operations, thus disabling themselves from being informed of the risks or problems requiring their attention. Now in Stone, the Delaware Supreme Court held that where directors fail to act in the face of a known duty to act, thereby demonstrating a conscious disregard for their responsibilities, they breach the duty of loyalty because they failed to act in good faith. In Stone, the Delaware Supreme Court further explained that the failure to act in good faith may result in liability because the requirement to act in good faith is a subsidiary element of the duty of loyalty. Now, because a showing of bad faith, as described in Disney and Caremark, is essential to oversight liability, it followed that the fiduciary duty violated by not exercising oversight was a violation of the duty of loyalty. Now, Stone's explanation of the interaction between good faith and loyalty resulted in two doctrinal consequences. First, although good faith may be described colloquially as part of a triad of fiduciary duties that includes care and loyalty, the obligation to act in good faith is not an independent fiduciary duty on the same footing as care and loyalty. The second doctrinal consequence was a recognition that the duty of loyalty is not limited to cases involving financial or other fiduciary conflicts of interest. It also includes cases where the fiduciary fails to act in good faith. As Vice Chancellor Strine said in the Gutman decision in the Court of Chancery, a director cannot act loyally towards the corporation unless she acts in good faith. Now in Stone, the plaintiff's complaint equated a bad outcome with bad faith. And the problem with the plaintiff's argument was a failure to recognize that directors' good faith exercise of their oversight responsibility may not invariably prevent employees from criminal conduct or other matters that may harm the corporation. In fact, both of those had occurred in Caremark and Graham. In the 1742 Sutton decision, the Lord Chancellor had stated, "It's by no means just in a judge, after bad consequences have arisen from any exercise of power, to say the fiduciary must have foreseen what would happen and therefore were guilty of a breach of trust." In Stone, in 2006, the Delaware Supreme Court held that in the absence of red flags, good faith in the context of oversight must be measured by the director's actions to ensure a reasonable information and reporting system, but not by second guessing after the occurrence of employee conduct that results in harm. The current financial crisis that was alluded to by Dean Fitz creates a perfect storm. It's something to be examined by the Institute for Law and Economics with experts from the law school, the Department of Economics, and the Wharton School. And undoubtedly, that cross-disciplinary analysis will be looking for red flags on all three fronts. But the Stone decision brings us back to loyalty today. After the Delaware Supreme Court's decision in Stone and Ritter, it's now clear that the fiduciary misconduct that implicates the duty of loyalty involves not only loyalty in the classic sense of self-interest, but it also includes bad faith. The other Delaware cases I've discussed also lead to another conclusion. The business judgment rule, as an equitable balancing between legalistic approaches and equitable principles, ensures that the decisions of Delaware directors will be respected unless the directors were interested, as we saw in Weinberger, unless they lacked independence, as we saw in Oracle and Scrushy, if they failed to act in good faith, as we discussed in Stone, or they acted in a manner that was grossly negligent, as was discussed in Van Gorkum. But as we've seen, gross negligence is really not going to be relevant in shareholder actions because most of the corporations have a 102(b)(7 provision. So that brings us back to loyalty. Plaintiffs must allege and prove a breach of the duty of loyalty, which includes good faith, if they're going to recover personal damages from the directors. I think you can see from my remarks this afternoon that Professor Rock was exactly right in three respects. First, Delaware fiduciary duty is best understood as a set of parables about good and bad directors. Second, Delaware judicial opinions over time yield reasonably determinative normative guidelines for directors. And third, therefore, Delaware fiduciary law is not mushy or blurred. In fact, I'd like to suggest to you that the focus is sharp and the focus of Delaware fiduciary law is on loyalty. Now you remember in the 1742 Sutton decision, the Lord Chancellor held that a fiduciary had a duty of fidelity. Fidelity is derived from the Latin word fidelis, which means loyalty or faithful. Today we're all aware of the fact that it's Veterans Day, and we pause to remember and honor those brave men and women who have preserved our freedom. In thinking about Veterans Day today, I also thought about the motto of the United States Marine Corps, Semper Fidelis. And I think that would be a good motto for the directors of Delaware corporations, and that's the moral of my story today.